Hi all, now this is part 2 from the video that Guy and myself made. Now this is the document. It should clarify what the judgment actually is. Now that judgment was given to us to confuse me, you and the general public at large, and the press fell for it. Now once you've read it and you can see what they tried to do, to mislead and confuse everyone, and then there's 2 other documents. The next document that follows is his judgment. That's the judgment he handed down. Now I've marked some arrows on it so you can see the parts that he's totally tried to mislead you on. Then below that is another document which is now in the court, it's in the system now, which they will not like. It's a request for review and revise, and once you read that you'll be able to see exactly where he's gone wrong or deliberately misled you. They will have to give us another hearing and clarify exactly what nonsense they're trying to do. So I hope this explains to all those people who've been confused that you now know what we believe, and for those that will still carry on to try and mislead you, don't believe them. So thank you very much, and on to the next battle. Cheers.
Your judgment is a goldmine. Jadaljahu Ebert. Analysis of the Tom and Sue Crawford judgment dated May 14, 2015. These notes are taken from an analysis of the judgment handed down by HHJ Godsmark QC in the application of Tom and Sue Crawford v Bradford and Bigley for leave to appeal out of time against the possession order to evict Tom and Sue Crawford from their home, and which was purported to still be in force. Judgment was handed down at Nottingham County Court on Thursday, May 14, 2015. This is taken from a conversation between Mr. Ebert and Tom regarding the judgment. For the record, this judgment consists of 104 paragraphs, whereas the actual order contains only 3 elements which are reproduced here. The order that I make is that permission to appeal out of time is granted but permission to appeal is refused. The suspension of execution of the warrant for possession of 3 Fear Chase is lifted. This analysis has been prepared in order to explain why it is that so many people have misunderstood the true meaning of the order, and that without a critical reading of the whole judgment, it would be very difficult, if not impossible, to fully understand why the judge had made such an order. Note: CaseMA refers to the court's case management database, which details every action taken in each case within its system. CPR 55 BDP 4.1. A step may only be taken using a possession claim online, on payment of the prescribed fee where the fee is payable. Tom and Sue have a printout of their CaseMA record. Anybody is entitled to a copy of theirs when they have or have had a case within the court system. It is a chronological list of each individual event in a case. PCOL is Possession Claims Online, the automated internet service which enables a creditor to initiate a claim for possession of property. Under this system, the courts will accept an application without a wet ink signature, and may help to explain of why the receipt for the application does not appear in the CaseMA printout. Paragraphs of the judgment have the original numbering, and the notes on each paragraph are in italics and follow immediately under each one. We start at number 49 as the previous paragraphs are accentually dealing mainly with the history. 49. I deal with this aspect of the case here, although it is not relevant to the appeal. This is an appeal against the making of the suspended possession order on September 19, 2012. What led to the lifting of that suspension is not relevant to the making of the original order. However, I deal with this point to make it clear that it has not been overlooked, and so that anyone reading this judgment can understand, as I have been keen to, how the Crawfords have ended up where they are. Which original order? There is no original. Your appeal is only on this order, and this order is a suspended one, and when it's suspended you don't appeal. It is not enforceable. This is not a possession order. This is suspended with conditions. So he's already confirmed that this appeal on a suspended isn't allowed. That's the reason he dismissed it. You can't appeal something which doesn't exist. You accept the point. There are much better ones. 54. Mr. Crawford says that there is no record of any fee being paid for the commencement of these proceedings on the court's CaseMA record system. The proceedings were issued online via PCOL, Possession Claims Online. Without the fee there is no valid claim. So what do you want? So now, he accepted that it's not on the record, there's no records that it was issued, so it's not a valid claim. And then followed by 55. I do not agree. I would not expect a fee paid through the online claims system to appear on CASMA. The PCOL system is largely automated and the claim form will not be generated unless fees criteria are met. Thank you very much. So have you got evidence of the fee? He hasn't got it, he stated it clearly. Unless fees criteria are met. They didn't meet them, they haven't got evidence that they were met, so it's not valid. 56. Furthermore, there is no separate fee for a possession hearing. Once the claim is issued via PCOL, there is no further possession hearing fee to record on CASMA. Here he is mixing it. He's twisted that you said that there was no fee paid for the hearing, but you're not disputing, according to this, that a fee was paid on the claim. 57. Sanctions for non-payment of certain court fees is provided for in CPR 3.7. This provides for service of notices requiring payment of certain specified fees, failing which an automatic strikeout follows. No such notice was sent out in this case. That is because there was no fee due in respect of any step identified in CPR 3.7, A.E. But you're not talking about the steps, you're talking about the issuing, so it's not valid. 58. Furthermore, proceedings are not invalidated by failure to pay a fee. If that were so, there would be no need to provide separately for strikeout under CPR 3.7. If the proceedings were invalidated for lack of a fee in the first place, there would be nothing to strike out. For proceedings to be struck out for failure to pay a fee, there must be a court order to that effect. There is none here. Yes, of course, because there was never any proceeding issued, so he's confirming it. What do you want to appeal? What are you asking him to strike out? Something that doesn't exist. 60. I should add also that I consider that the authority and validity of a court order comes from the judge. Where a judge makes an order, then that order stands until set aside by a further order. Its validity is not dependent on whether a fee was or was not paid at some stage during the process. He's right, because it's under Part 11. The judge did not hold jurisdiction to make the order because there was no proceeding issued by the court. To quote, its validity is not dependent on whether a fee was or was not paid at some stage during the process. But there wasn't a process at all, you couldn't pay it during, you'd have to pay at the beginning to start the process. The court never issued it, and if the judge mixes in something that was not proceeding, then he didn't have jurisdiction. That's Part 11. 61. Whilst I acknowledge that an order would not be valid if a judge had no power or jurisdiction to make the order, that is not the position here. These were mortgage possession proceedings. The county court has jurisdiction to deal with such proceedings, and district judges with deputy district judges are empowered to exercise that jurisdiction of the county court. The judge's statement, "That is not the position here," is an assumption based on hearsay. Where is the evidence to justify the hearsay? And you can't make a judgment on an assumption. But now we are coming to the main point. The Unfair Contract Terms Act 1977. 62. Attention is drawn to the Unfair Contract Terms Act 1977 and in particular S10. This is concerned with secondary contracts which seek to evade the provisions of the Act. Mr. Crawford's reliance upon the 1977 Act is premised on a unilateral change in his mortgage conditions undertaken by Bradford and Bigley. However, this point is misconceived. One of the agreed facts in this case is that there was no change in mortgage to a capital repayment. The terms of the mortgage remained as they had started out and there is no secondary contract. So he made a decision that both parties agree that there was never a change, that only the starting one is valid. And what is the starting one? An endowment one. So does he state that it is agreed by all the parties that this is the only contract? Yes. So you won the case. This is what everybody says about that. He has established that this was an endowment contract and he accepts that. They have written that they have changed it, but he's made a decision which agrees with this point. So you have got here a judicial decision, agreeing in front of a judge that there was no change in the capital repayment and that there is no secondary contract. The first one is the valid one. And there is no question that the first one was an endowment one. So, he has confirmed it now. He has made a judicial decision now, so we are dealing with one contract and this is an endowment. Issues like where is the money, why is the money, how is the money, this is not the issue, this is the contract. Repudiation. 63. Mr. Crawford suggests that Bradford and Bigley reneged on the terms of the original mortgage agreement, thus repudiating it. Leaving aside questions of acceptance of repudiation or affirmation of contract, this point must also fail on the agreed facts. Mr. Crawford says that Bradford and Bigly's imposition upon him of a payment mortgage to which he never agreed is a repudiation of the original contract. However, again, it is agreed that there was no change in mortgage. Bradford and Bigly offered to change the Crawfords to a payment mortgage, but Mr. Crawford declined. Thereafter the mortgage continued under its original terms. There was no repudiation, let alone acceptance of such. So it's a super paragraph. Don't forget one thing. What you are reading now is not, he says, they say. It's a judicial decision. He's made a decision based on the fact that both parties agree that there was no change in contract. So he's right. If there was no change in contract, then you can't say unfair contract. They are in breach of a contract, but not through unfair contract. You see how to read a judgment. Let us repeat, thereafter the mortgage continued under its original terms. Please keep this in your mind. This was always the Crawfords' question. What the bank said or wrote was never relevant to this. 65. The problem with the submission is that both sides agree that there was no subsequent mortgage contract replacing the original 1988 mortgage agreement. This is the same factual point. Mr. Crawford asserts that he never agreed to go on to a repayment mortgage, but then Bradford and Bigly do not say that he ever did. The mortgage stayed as it was. So up till now you've got all these 4 paragraphs in such a big judgment confirming that there was no change, and the only one that existed was an endowment one. 67. I also wondered whether Mr. Crawford was confusing a contract for a mortgage with the mortgage deed itself. The S2 Law of Property, Miscellaneous Provisions, Act 1989 formalities apply only to a contract for a mortgage. Unless those formalities are complied with, a party is not contractually obliged to execute a mortgage. But that does not affect the validity of a mortgage deed which is actually executed. The formalities of a deed are governed by S53 Law of Property Act 1925, and they are complied with in this case. The distinction was authoritatively emphasized by the Court of Appeal in Helde v. Strathmore Limited, 2011, UCAR Civilian 542. That's what was executed, so he is affirming to you once again the point that there is no second contract. 80. However, at the possession hearing the claim was advanced simply on the basis of more than 2 months' arrears. I have looked at the witness statement of Michelle Tui in support. It makes no representations that Mr. Crawford consented to a change in mortgage terms. Indeed, as observed above, one of the agreed facts in this case is that both sides accept that there was no change in the mortgage. I can find no basis for saying that any statements of the nature identified by Mr. Crawford were made to the court. The judge has looked at the witness statement of Michelle Tui but not the accounts. It is hearsay and cannot be relied on. He then goes on to say that the witness statement makes no representations that Mr. Crawford consented to a change in mortgage terms. So the judge accepts Mr. Crawford's version and indeed has already made a decision to that effect. 82. This is dealt with by what has gone before. As I have already observed, a key mutually agreed fact in this case is that the Crawfords' mortgage did not change. Sadly, it would have been so much better for them if it had. The judge affirms in very clear language that the mortgage did not change. It would have been so much better for them if it had. Better for the bank, that is. Arrears capitalization. 83. Mr. Crawford disputes the accuracy of the arrears figure claimed and also points to the capitalization of arrears undertaken by Bradford and Bigly. Mr. Crawford submits that if arrears have indeed been capitalized, then I am bound by the Northern Irish case of Bank of Scotland v Macready, 2014, NI Master 11 to rule that Bradford and Bigly have made an unconscionably illegal claim against him. This would also constitute a clog on the equity of redemption. The judge says that the arrears have been capitalized, and capitalized arrears are not an arrear. This means that they are claiming the arrears as a capital. Therefore the bank cannot take a claim against you. The claim against you is illegal. They are claiming the arrears as capital. This is an equity issue. You haven't any arrears, and possession can only be taken on arrears. He made it clear that they acted illegally. 85. The case of Macready confirmed that when arrears are consolidated they cease to be arrears, and in doing so acknowledged the authority and correctness of the Court of Appeal in Zidder. See paragraph 32 onwards in Macready. In the case of Macready, the court refused to allow the bank to both capitalize arrears and rely upon the arrears so consolidated as being outstanding arrears for the purposes of possession proceedings. It was simply an application of the principle that arrears, once capitalized, cease to be arrears and cannot be relied upon as such in a possession claim. There was nothing novel about that. So he's saying that the possession proceedings are not valid because the arrears have been capitalized and you can only take possession on the arrears and not on the capital. It's a capital debt, there are no arrears. It's a bombshell what you have got here. He writes clearly, if it's a capital debt you can't issue possession proceedings. 89 What Bradford and Bigley cannot do is rely upon previously capitalized arrears in this possession claim. They are not doing so. The last capitalization was in December 2006. These proceedings were brought on the basis of failure to make mortgage payments in 2012. So he's saying that when they now take proceedings, it's capitalized, the bank is asking for the full amount including the arrears. But if there are no arrears, the proceedings are not valid at all. And you paid all the arrears, and if there are no arrears then possession proceedings are not valid, that's what he writes. The proceedings were brought on the basis of failure to make mortgage payments. But you paid everything. There is no order for possession. There was one because you had arrears, but that was suspended, they gave you time to sort it out. So he confirms that if the facts are, as we know, that the arrears were paid, so the proceedings are illegal. 91 Here, Mr. Crawford has a point. I can find nothing on the statements of account which show when capitalizations have occurred, although the total mortgage debt figures are more readily understandable. From January 2010 the format of statements of account changed, but it is not easy to see at any given time what the live account arrears are. At the time of commencement of the possession proceedings arrears were said to total £1,802.90. That is not a figure which I could identify from the statements of account. When asked where it had come from, Miss Sardles for Bradford and Bigley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. The judge states that it is not easy to see at any given time what the live account arrears are. The reason for this is that the Crawfords paid the arrears. So Mr. Crawford has a point, but the judge did not establish the point. He couldn't establish it because he did not have the accounts. But Mr. Crawford has got the evidence that he paid it because he has the bank statements. Next, the judge says that he could not identify the figure of £1,892.90. This is for the simple reason that he did not have the accounts. All he has is the balance. Mr. Crawford paid it, that's the reason he can't identify it. Once again, the judge states. When asked where it had come from, Miss Sardles for Bradford and Bigley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. That's the reason she's not coming to court. This is a slap in the face from the judge. He's saying it clearly, is it not a bombshell? He says it is not satisfactory, and this is enough. You don't have to call it a lie. But he's not satisfied with her response that the computer is our slave, and not our master, but she is the master, eh? So he says, I'm not satisfied with your response. And this is a killer for the whole case. Because you can prove that he wouldn't be satisfied with many things that they say. And the point is that they say everything was fraud. It's a slap in the face, it's not satisfactory, the judge has decided it. There were no statements, the only statements were in affidavits or skeleton arguments. It's all hearsay and they didn't prove it. Therefore he said it's not satisfactory, so I don't believe your statements, or your statement is not valid and I can't take it into account. So take away all your skeletons, all your statements of truth and affidavits, and throw them in the bin. So now do you understand why she's not coming to court? Her skeleton arguments are dead. I want you to understand how beautiful it is. Excuse me, until I showed you this, how do you explain it, then? She said, it was stupid, that computers are our slave, not our master is her statement. Without proving it. He didn't want to say you've perjured yourself, you're a criminal and so on. You don't expect it in the civil court, it's enough that the judge says I dismiss your statement, or it's not satisfactory. In pure English, in normal language, you lied. Can you tell me another explanation? Or am I completely out of order talking rubbish? 92 However, none of this helps Mr. Crawford in relation to possession. The entitlement to possession is triggered by arrears amounting to 2 monthly installments, and no one suggests that such qualifying arrears did not exist both at the time the claim was issued and on the date of the order. Of course, because there is no order. It's a suspended order giving you the opportunity to pay the mortgage arrears, which gave you 6 months and you did it. So there was never an order. A suspended order is not an order. and at the end of it, when you stopped paying, everything was paid as of today. 93. That does not mean that Mr. Crawford is not entitled to challenge the totality of the debt. He can still do so when an account is taken of how monies are to be paid following sale of the property. Thank you very much. He hasn't got any knowledge of what the debt is. He has not had produced to him accurate accounts. But Mr. Crawford is entitled to establish it. This is the next step. He says this will follow after the sale. No, sir, it doesn't follow after the sale. It follows before you go to the sale. You have to prove that there was any debt. So, now this case is dead. To go and sell they need an order from the court for a sale. So they can't use the charge, because they are trespassing, in my opinion. Did he make it clear or not? Conclusion. 96. The Crawfords are fighting for their home of 25 years. Their desperation is easy to understand and their predicament has attracted interest in the press and much public support. When the case came before me in February 2015, I was troubled that at the end of the mortgage term the Crawfords owed more than they had originally borrowed. So why didn't he establish it? Why didn't he establish that there was a debt? So he didn't finish the job. There were no accounts, so he didn't finish the job. So anything he had done before, which was in your favor, on an assumption, but you can convert that assumption to fact. But you don't have to confirm it. They have to prove that the debt exists. So he has opened you the door now, for the future, that you have got a case. And he's stated here, according to this, that they have to prove the debt. He has certainly opened the door for you for the next after this hearing, after this judgment, so your door is open. 97. Factually the position is now clearer. The reason that the Crawfords owed more at the end of the mortgage than they did at the beginning is that there is no longer an endowment policy which was supposed to repay the capital borrowed. However that came about, the Crawfords have known since at least 1999 that there was no means in place of repaying the original capital. Mr. Crawford was offered the means to repay capital by way of a repayment mortgage but refused. That explains how we have ended up at the end of the mortgage term without repayment of capital. 99. The order under appeal is a mortgage possession order. As I have indicated in paragraph 50 above, once there are qualifying arrears, 2 months installments, Bradford and Bigley is entitled to possession. There was no dispute that there were qualifying arrears. The order under appeal is a suspended order. This is misleading. The suspended order under the appeal is a mortgage possession order. There is no such order, but the proceedings are on mortgage. The judge then states that there was no dispute that there were qualifying arrears. This is an assumption by him. If it's true, and you have the evidence, and you know that you did pay, and he also knew about it, so there was no arrears. So they couldn't make a possession order. To clarify, Bradford and Bigley took the Crawfords to court in 2012 to obtain a possession order against them. There had been arrears in previous years, but these had been capitalized and so could not be used as grounds for possession. In 2012 the Crawfords were 2 months in arrears and the B&B took them to court over the 2 months arrears. The court decided to give the Crawfords the opportunity to pay the arrears, and they did pay them. So it was finished, and the proceeding on arrears doesn't exist anymore. And on capital you can't ask for possession, only on arrears. And in any event, if there had been arrears in 2012, then in 2014, when they want to evict you, if there were arrears they were capitalized. Because they say the mortgage arrears, the B&B keep pushing the argument that because the Crawfords have not paid off the capital at the end of the mortgage, that arrears have once more built up. But the Crawfords did not have to pay the capital because the endowment had to pay it. That's what the judge is saying. They say you have to pay separately, but this is a different issue. But there are no arrears, so therefore there are no possession proceedings. There is a recovery of debt, it's not a possession issue. Now, on the recovery of debt, they are secured. They have got a charge on the property, but now, you will say that the charge is a trespass because you don't owe a P. For the purpose of what you are fighting, about eviction, they can't evict you on the capital on the property. Does the judge not confirm that this is the law? And you are well aware that you did pay the arrears. So those proceedings which were apparently about 2 months arrears, those arrears have been paid. So there were no arrears and there can't be any possession, they can't rely on something that was not there. 100. Mr. Crawford has raised a number of points which he says should ground an appeal. I have scrutinized the points made by Mr. Crawford in this hearing with care. Due to the public interest, I have attempted above to set out as simply as I can the law which applies in this case and my analysis of Mr. Crawford's legal submissions. He's right, he did it. How did he do it? Assumption. He didn't know the facts. He didn't have any accounts, and he said you've got a point. The whole lot is an assumption. The issue here is very clear because he said clearly in the beginning that you have got a point. So the point has not been established. He's only assuming. He can't find the debt. He doesn't know where it is. It should have been capitalized, it is capitalized. If it's capitalized it is not an arrears, and if it's not an arrears the possession is illegal. So all that he's been doing is a marvelous job. Your position stayed in law. Now, to match it to your case, he didn't have the papers to match it. And he says he cannot rely on their statement because they are not a master, it's not satisfactory, their position. So in answer to their position, he cannot make a decision. 101 The points made by Mr. Crawford are either without foundation or legally misconceived. Factual assertions about changing the terms of the mortgage are misplaced. Both sides agree that the mortgage terms were not changed. The legal challenges raised are misconceived, and I have set out in detail above why that is so. The judge did not have the evidence to rebut you. They didn't put forward any evidence, so how can he say that they are misconceived? He is making an assumption. And once again, in conclusion, the judge confirms that the mortgage terms were not changed. 102 None of the points raised by Mr. Crawford have any substance in terms of potentially defending the possession claim. None of them can be described as a point with a real prospect of success on appeal. How can he make this statement? Did he have the evidence? It's a wrong decision, it's strong language he's used, but it's an assumption, and if we want to take him to the cleaners, which I don't want to because you've won it in a big way now. We can establish that paragraph 102 is based on assumption, and then his statement falls automatically. But you don't need it for the moment. 103. I have considered separately whether there is some other compelling reason why an appeal should be heard. Although this case is unique to Mr. Crawford, it is sadly one of many similar cases with which the courts deal all the time. It raises no new point of principle. So he's making a decision on principle, not on facts. How do you like that? 104 The order that I make is that permission to appeal out of time is granted but permission to appeal is refused. The suspension of execution of the warrant for possession of 3 foreclose is lifted. So he has confused you, on the basis of assumption. He's saying there is a point, there is this, but he didn't have evidence, so it's rubbish. But then what he says next, the suspension of the execution of the warrant for possession of 3 foreclose is lifted. Now after I went through with you, after I read everything, let me tell you, even what you dreamed, in your dreams, yes, and everybody will say blah, corruption. The word execution is important. He hasn't got a warrant. Let me finish my point. You know I'm looking outside the box. The warrant must identify all the questions or all this assumption. The warrant should be written, must be written the amount, how much paid, how much not paid, and all the accounts attached. And you know the warrant looks 000 debt. Ah, you see how beautiful it is. And he agreed that he hasn't got the warrant, he didn't set aside the warrant. He admitted that the order he dealt with was a suspended order. A suspended order, you have to look at what are the conditions. Are you in breach of the conditions? Then they have to make a new order, anyhow. A possession order must be in date. He didn't have this. He's stated clearly that it's suspended. Did he look into the conditions? Have they been fulfilled or not? His only consideration for the whole proceeding that can take place is 2 months in arrears, not the capital. Nothing capital is not a possession issue. Does he say it clearly? Does he say that the possession is based on 2 months arrears? Can you prove that the 2 months has been paid? Yes. So what do you want more with that? Now you understand why she's not coming to court. Because he can take her to the cleaners if he gets hold of her, do you understand? He can convert her unsatisfactory to a lie. Or he can convert it to inaccurate, misleading or false. Even inaccurate is contempt of court. So therefore she's not coming to court, and she does not want to oppose any point which he made in this decision. And she's not even asking for costs. She can't because she's lost it. She's lost it in a big way, and to prevent the embarrassment, she's simply not coming. But now you've got the answer to all your questions. And in answer to your question about what to do when you go to court for the handing down of the judgment, I'll tell you what to do, and if you change it, you'll bury yourself. You tell all the people they don't have to come, it's a waste of time. You should put your post up because people will come for nothing. Now, when you come to court, you walk in, and sit on your place. The judge will come in, and say good morning, and will say I'm handing down the judgment. I'm going to make the order which I specified or whatever it is. And you know already what the order is, he wrote it. And he'll ask you, have you got anything to say, Mr. Crawford? You stand up, and say thank you very much, my lord. You gave a fantastic judgment, you identified all the problems which we went through precisely in the last 10 years. Thanks, bye. So there you have it, God's mark judgment handed down was to confuse and mislead us all. He did not just stop with the judgment, he tried to continue with the order he made, which a copy is below. Now he is in real trouble. The next document that I have now put in court is my request, review and revise. Read and compare his order with my request and you will see where he tried to confuse and mislead not only us but the general public, as the order is in the public domain. Thomas Crawford and Susan Crawford. 3 Fear Chase, Carlton, Nottingham, NG4 1DN, Nottingham County / High Court, 60 Canal Street, Nottingham, England, NG1 7EJ. 25th of May 2015, case number 2PB03485. Request, review and revise. Grounds. 1. The order does not correspond to the judgment pronounced in court on the 14th of May 2015, it is inaccurate, misleading, and false in fact and in law. 2. There was no documentary evidence in response and / or any defense on the detailed statements on the claim. 3. The statement in the order, 2. Permission to appeal refused, is inaccurate as the judicial findings there was no case to appeal, as the court affirms that there was only one mortgage deed, endowment mortgage. There was never any secondary mortgage as Bradford and Bigley plc presented to the court. 4. In the order, the stay of execution of the warrant of 3 Fear Chase, Carlton, Nottingham, is lifted. The correction that should be made in the order, the stay of execution of the warrant, notice of evictio, of the warrant, as the warrant was not in front of the court, is lifted. We wait a speedy inter-party hearing which will only take 30 minimum to deal with. We are fully responsible for the statements above. Statement of truth. T. Crawford S. Crawford. May the 25th, 2015. May the 25th, 2015. Justice delayed is justice denied. CC, to whom it may concern.
Debt Free TV, in association with GetOutOfDebtFree.org.